Good morning, everyone, or afternoon now, technically. Welcome aboard. I will just slowly kill time while everyone connects, because I know there's a bit of a delay and a lag, but welcome aboard. Welcome to the Alexander Lloyd and DMH Stallard Employment Law Update. It's lovely to have you on board. Right, I'm going to do some screen sharing while you all connect. There we are. So while everyone's connecting, would obviously like to welcome you aboard. As I say, Alexander Lloyd and DMH Stallard present an employment law update, which we're going to cover. Basically, this is the second in a series of webinars we've been delivering this year. This time in partnership with Rebecca Thornley-Gibson from DMH Stallard. Hello, Rebecca.
Hi there. Hi, everybody.
So I've been co-hosting, I suppose, or sharing this platform with Rebecca for about 18 years now, which is pretty upsetting for both of us, I think, in terms of time frame. But lovely to keep this collaboration going. As I said, today we're going to plan to cover a bit of a general update on employment law from Rebecca, with some examples of recent cases and important legislative developments. We're also going to delve a little deeper into the future of restrictive covenants, which basically currently under government review. We'll examine how these covenants can be used for business benefit and what potential changes may arise as a result of the current consultation taking place. The presentation has three sort of natural sections. So via the Q&A button, which you should see at the bottom of your screen, we will invite questions through that, and I'll pose a selection of these questions to Rebecca at the end of each section. We anticipate an hour in total, and hopefully that answers most of your questions. The slides and so on should be available to you all at the end, and we are recording this, so if you want to go back and watch it again or share with your teams, that should all be available to you. So moving swiftly on. Here's my little plug, I suppose, for Alexander Lloyd. Hopefully by now, most of you know me and the team. Our job, HR recruitment across the southeast of the UK. There's myself, Damien, Theo and Danielle. We work with any shape or size business, any sector, from SME through to global blue chip, based in Surrey, Sussex, Kent and London. I think it pretty Ron Seal, does what it says on the tin. We are also the creators of the Talk HR UK podcast. We release bi-weekly at the moment. I think there's about 20 odd episodes available on Apple, Spotify and Google podcasts for you to listen. And we have a YouTube channel for you to watch. So if you're that way inclined and would like to feast on the various HR conversations we've been having with HR leaders, they're there for you. So there we go. But with no further ado, I suppose I should mention the feedback form. So at the end of the podcast, a feedback form should automatically land with you immediately. If you could complete that there and then, that would really help Rebecca and I with future topics and how today's gone. But with no further ado, I will pass over to Rebecca. I'm on the slides today, so apologies in advance, but fingers crossed, that's the right set of slides for you.
Excellent. Thank you very much, Simon, and thank you for being my slide mover. So I will prompt you at the relevant moments. But good afternoon, everybody, and thank you for joining. 55 minutes is effectively what I've got to go through some legislation that is coming up, some legislation that has passed in the past few months, and some case law that's developing, and there's been some fairly monumental cases in the last couple of weeks that have come out, Uber being one of them, of course. And then I think it's probably quite relevant to look at the future of restrictive covenants as well, because there's been a government consultation on that, which will be quite interesting to see what they do about the restrictions put on employees by employers, and whether that impacts on sort of the general sort of economy and movement of workers from organisation to organisation. So a lot to get through, and we'll keep an eye on the Q&A, or I know Simon's going to keep an eye on the Q&A, and at the end of each section we'll we'll try and deal with as many of those as we can, but obviously we might not be able to deal with all of them, so apologies in advance. So moving firstly to something that you might well have thought, gosh, Brexit, blink, and you probably missed Brexit this year, because there have been other stars in the employment world that probably meant that Brexit wasn't the #1 priority, like a lot of HR professionals thought it probably would be. So Simon, if we can just have a look at the next slide and just remind everybody that we did, of course, have Brexit, and that received royal assent in January of 2020. And from the 1st of January 2021 is really when we have seen, or will see, changes to how the courts and the tribunals are going to interpret what was EU law for the purposes of our UK employment. What has happened with the EU law is that effectively it's all been created and put into UK law. What that means is that things such as the working time regulations, the Equality Act, 2P, that all derive from EU directives, those are now all effectively subsumed within UK law. And when decisions are made by the tribunals and by the courts, they no longer have to look at the European court cases, and they can actually interpret those cases as they wish to. So we're no longer bound by that previous EU body of case law. What's likely to happen is that courts and tribunals will probably be quite influenced by it, but they certainly don't have to follow it. So, as I say, you know, it sort of slipped into being on the 1st of January 2021, but I think we're all still grappling with all things COVID related and pandemic related. But it is worth a mention. And so next slide, you know, obviously this isn't a webinar about COVID, but it needs to be mentioned again. We're 12 months in to the pandemic in terms of various emergency measures that were implemented. A lifeline, obviously, of furlough that was announced by the Chancellor last March, at the end of last March, and obviously all of you and all of us employment lawyers, you know, spent quite a long time getting our heads around quite what the impact of furlough was going to mean. And we then, in the second phase, we're getting our heads around a lot of workforce planning issues and who could be retained, how businesses needed to change, and unfortunately, redundancy programs were relatively common. I don't think any of us thought that, you know, come March 2021, we would still be talking about furlough in terms of it being still in operation, but it's still in operation until September 2021, which is a massive relief for a lot of industries, particularly travel, hospitality, leisure. Obviously, retail will be opening next month, fingers crossed, if the roadmap goes to plan. But, you know, the furlough scheme has prevented job losses, not all job losses, and, you know, businesses have had to change and realise that even with furlough, they needed to make job losses. But that furlough scheme is there, thank goodness, with just a reminder of the employer contributions. In July, employers will have to contribute 10% towards that 80% cost, and then in August and September, that will increase to 20%. What we've also had as well, and it may impact some of you on today's webinar, is we've had the self-employed grants that have been given by the government, and HMRC contact those that are effectively eligible for the grants. And we've got the 4th and 5th grants that are coming up. So that's 80% of 3 months worth of trading profits, up to a maximum of £7,500. for each grant period. So we've got the 5th grant coming up May to September, which is a little bit different though. The difference there is that that 5th grant will be almost means tested. So if profits haven't fallen by less than 30%, then you won't get the full 80% grant. You won't get the full £7,500. What you will get is 30% of the 80%. And then I think it's worth mentioning, there was new legislation brought in relation to annual leave as a result of COVID, which effectively allowed the carryover of annual leave where employees had not been able to take it because of something related to the pandemic. Now, I think a lot of employees simply didn't take holidays because there was nowhere to go. There has been this, saving up of holidays and this backlog, an emerging problem that employees are going to be saying, well, I've got my holiday from 2020. And I know there's legislation that allows me to carry quite a lot of that over. So you've got a 2020 plus 2021 holiday situation, maybe at the end of this year, second half of this year, when things start getting a little bit more back to normal, people will want to take quite a lot of holiday. So I think, again, HR needs to audit and needs to put in place holiday policies specifically to deal with that. So that might be a requirement for employees to take so much of their holiday, in the next couple of months. And then obviously the realization that just because you've got lots of holiday doesn't necessarily mean that you are going to be allowed to take it all in one block or when perhaps the employee wants to take it. So just keep an eye on that, because I think it's going to be a bit of a stick that employees are going to be beating us up with later in the year. Okay, next slide. We always see in April what we call the annual rate increases. They're relatively modest. I did wonder whether they were going to be frozen this year so that they didn't create an extra financial burden on employers, but they haven't been. So the figures are there and you'll have the slides. So I'm not going to say anything about them specifically, other than in terms of the national minimum wage increase, please be aware that the national living wage is now applicable for the 23s and over. Previously it was 25 and over. So again, it's a case of having a look at your employees, and those who are 23 and over now are entitled to the national living wage. So obviously a benefit to those employees, but an extra wage cost for businesses. I just want to say one quick thing about the redundancy pay. So maximum weeks pay for redundancy going up to 544. That will take effect from early April. What it doesn't mean necessarily, though, is that you can make somebody redundant on the 31st of March and think, oh, well, we've not had to pay them that increased amount. It's not that much. So, unless you've got a particularly long server, it won't make too much of an impact. But with statutory redundancy pay, the actual termination date is worked out on the basis of adding on the statutory notice. So somebody made redundant on the 31st of March, you actually calculate their redundancy pay as if they'd been made redundant at the end of what their statutory notice period would have been, even if you pay them pile-on. So it's a point that's quite often missed by employers. So it's just one I just want to flag up. Okay, just carrying on with the holiday pay theme on the next slide. The ruling actually came in April of last year in relation to how you calculate holiday pay for people with variable pay and variable hours. It used to be that you looked at the last 12 weeks and did an average of that, the last 12 weeks when they'd actually earned pay. Now that created all sorts of issues in terms of people that may well have quite quite fluctuating salaries and would provide, sort of seasonal variations. So somebody might take their holiday at a point where they hadn't been paid very much in the previous 12 weeks, and that could have been a deterrent, taking their holiday then. And working time regulations don't like things that create a deterrent for people taking holidays. So as of last year, the reference period for variable pay or hours employees was increased to 52 weeks to ensure that calculation and any bumps in seasonality was clearly ironed out. Now, if you've got a worker if you've got a worker, obviously holiday pay is workers and employees, but if you've got workers and employees who have not been with you for 52 weeks, then you just do an average of the amount of weeks that they have been employed. But what the legislation also made clear when it came in last year as well, and just on the next slide, is they appreciated that you couldn't look back, sort of a huge period of time if somebody hadn't worked and received pay in the last 52 weeks. So if, for example, somebody had been on maternity leave. So what the legislation did was to actually put a limitation on how far back employers should actually look, and they only need to look back 104 complete weeks, so 2 years effectively, to do the averaging if somebody hasn't worked for some of those previous 52 weeks. Okay, so next slide. I just want to say a little bit about immigration. Now, I'm not an immigration specialist. We have immigration specialists at DMH, but I think it is worth making it clear that the immigration landscape is very dynamic. Brexit obviously has removed the right to freedom of movement for EU nationals and EEA nationals. And there will be new rules in place on right to work checks from July 2021 in respect of EU and EEA nationals. Now, unfortunately, the government hasn't put out yet what those new rules will be. There is what's called a grace period from the 1st of January 2021 until 1st of July, 30th of June 2021, where the right to work checking is the same as it's always been. So you can check on the basis of passport, etc. What will happen from 1st of July 2021 is effectively you'll be checking on the basis of immigration status. So do keep an eye out on right to work check guidance that will be coming out. Also keep an eye out for any EU, EEA nationals that are employed by you, that they have put their applications in for the UK settlement scheme, because the deadline for that is coming up 30th of June 2021. So again, it's worth just doing an audit of your staff to check on that particular matter. Next slide is IR35. Hopefully all of you will have done your preparatory work on this. All of you will have looked at the responsibility you might have as an end user client to do status determination statements. If you're the fee payer as well, which often you will be if you're the end user client, directly contracting with somebody who has usually a personal service company, then you'll not only have the responsibility for the status determination statements, but you'll also have the responsibility if somebody has what we call deemed employment status for dealing with the deductions of tax, national insurance and the apprenticeship levy. So I think IR35 is going to prove quite a headache going forwards in 2021. There's already been lots of queries we've received as to what the deemed employment status is. The CEST test tool that HMRC have said is going to be, HMRC will effectively rely on the CESS test outcome, provided you have inputted the answers in a genuinely truthful way. But the CESS test is proving inconclusive, so not giving you any status in about 20–25% of cases. So there will be a situation whereby you'll start to look at whether you do something other than looking at the CESS test and start to look at individual cases themselves. Now, I think, you know, some people thought that IR35 might get pushed back because of the budget, and the March 2021 budget, which, you know, might try and give again employers a little bit of a breathing space on having to deal with all things IR35 in the private sector. But no, it is here to stay, and obviously it's a way in which HMRC can collect more revenue, so why wouldn't they implement it following last year's delay? Okay, just moving forwards to some potential changes to tribunals. So last year there was a commission report which laid out a number of recommendations on the basis of what happens to employment tribunals. One of those was looking at whether time limits should be increased to 6 months for all claims. Now, that is, I think, quite worrying for employers. It's hard enough now waiting for 3 months to actually see whether a departing employee or an employee who's got a discrimination claim is going to bring a claim. And we all know it's not 3 months. We all know it can, you know, be longer than that, on the basis that by the time, you know, sort of it's gone through the ACAS process, by the time it's gone through, you know, sort of the admin sort of processes, and by the time it actually gets to you, it can feel a lot longer than 3 months since that departing employee, you know, sort of was with you. If they're increasing time limits to 6 months, you're going to be twiddling the thumbs quite a while to, you know, sort of work out if you've got a problem in respect of that exiting employee, or that employee who might have raised a discrimination grievance. And then contract claims was the other key aspect of the commission report, in that at the moment, any breach of contract claims in the tribunals have a damages limit of £25,000. And what that means is that if there is a contract claim which is in excess of £25,000, employees either have to say, okay, well, I won't claim that because I'm going to the tribunal, or they in effect have to issue their claim in either the county court or the high court, which brings about quite significant costs, burdens, and employees don't tend to like to be at risk of costs. The county courts and high courts work on the basis that the loser will pay the winner's costs, whereas we know the tribunals are you know, sort of much more liberal in respect of that, and, you know, costs are usually only awarded where somebody had no chance at all with their case, or where somebody has acted unreasonably in the course of the proceedings. If contract claims are increased to £100,000, that does potentially give a lot more scope for employees to, you know, bring heftier claims, and for the risk of compensation in terms of breach of contract claims to be quite an exposure for employers. So that's a real whiz through some of the legislation. Simon, I don't know whether there have been any questions. I can see it, if I just put my big fat finger on the Q&A button.
We do. So I won't name the people, but thank you for your questions. So one question, I'm not sure if we addressed this in the later slide. We've been saying that no relaxed holiday carryover at this organisation unless we stop people taking leave due to COVID. So if they chose not to take leave, as COVID meant there was nowhere to go, we're saying our usual carryover rules apply with no 2-year carryover. Is that safe and reasonable?
Okay, so yeah, so if you are happy that they have the ability to take their leave, and that could be taking their leave at home, you know, we don't have to go to, you Spain to take our leave. We don't even have to go to somewhere else in the UK to take our leave. We can still take our leave at home. So I think my view would be that if you have said, look, you can take leave and we've asked you to take leave and there's nothing that has stopped you taking leave, then yes, then your usual carryover rules will be fine. The legislation that was introduced on the COVID annual leave was really to look at people who were working, a lot of hours. So your supermarket employees, your healthcare staff, your care workers, delivery drivers who, couldn't take their annual leave because they were really too busy. But unfortunately, the government sort of in its drafting missed a bit of a trick in making that clear. But I think that you will be able to justify saying to people, I'm sorry, but you can't carry over your 4 weeks over 2 years because we let you have the opportunity to take your leave. So I think on that basis you should be fine.
Thank you. So another question: if by the 1st of July an EU colleague has not settled or pre-settled status, would they potentially not have the right to work in the UK?
Well, it depends on their immigration status at that point, what visas they might have got, but they wouldn't have necessarily the right to work in the UK simply by being an EU or EEA citizen. So yes, that is the problem. That's why it's so important that you're carrying out the audits that people have applied for that settled status by settled status by the 30th of June. Otherwise, you're going to have to be looking at, well, what does give them a right to work in the UK, and it will be on an immigration basis. So do they have a skilled worker visa, and are you going to sponsor them in respect of that visa?
Thank you. And lastly, so do we have to include commission payments when calculating holiday pay? So their specific commission scheme means someone could earn, say, 50k commission in 1 month after signing a deal they've been working on for over a year, and then their average holiday pay for the next 52 weeks will be significantly higher.
Unfortunately, commission payments, it's quite clear from the court decisions over the last few years that commission payments are a component that has to be included in the holiday pay calculation. So commission is earned as part of the performance of their duties. And yes, I'm afraid it does have to be included. And just to make that person who asked that question scratch their head even more and possibly put their head in their hands, we've also got some cases coming up on voluntary overtime and Supreme Court decisions coming up on whether voluntary overtime is also going to be included within the holiday pay. We know compulsory overtime has to be, but voluntary overtime, it probably will have to be. So yeah, just a word of warning to keep your eye out on that.
Thanks, Rebecca.
Okay, right, I'm going to go through a few cases. Obviously every year there are so many cases, every month there are so many cases, but I wanted to just pick out a few that have been sort of moving up the appellate courts, moving up from the EAT to the Court of Appeal to the Supreme Court, and which now are starting to give us, clarity that we haven't had before. So the first couple of cases relate to vicarious liability, which is a concept in employment law that I think most of you will probably be familiar with. Effectively, the employer is responsible for the acts of its employees if those acts are done in the course of employment. And that's a very broad brush approach with regards to vicarious liability, but that's the general principle. Now, vicarious liability was starting to get a little bit out of hand, and employers were thinking, gosh, are we absolutely responsible for everything that our employees do? And in the Barclays Bank case, which was brought as a class action by various ex-employees, Barclays Bank were sued on the basis of medical reports that they obtained when an employee started work, and on the basis that it was quite a tragic case, on the basis that the doctor that they used for these medical reports, that was self-employed, not employed by Barclays, but was effectively, used by Barclays on a self-employed basis, that doctor carried out a number of sexual assaults on staff. Now, the staff members who had suffered the sexual assaults said, well, actually, Barclays, it's your fault. You're liable for the acts of the doctor. And Barclays defended it on the basis of, well, no, he wasn't an employee, and we can't be responsible for everything. And self-employment should not give rise to vicarious liability. And the Supreme Court held unanimously that's absolutely right. Vicarious liability cannot go that far to extend to being responsible for the acts of self-employed individuals. So I think from an employer point of view, that's a good decision. Obviously, it's not a good decision really for anybody on the basis of it's such a horrible case, but from the employee's point of view, they had no one to actually then go and sue. I think the doctor, the doctor just wasn't around and certainly wouldn't have had the financial wherewithal to pay out on the damages anyway that the employees were potentially seeking. So so Barclays Bank confirming self-employment doesn't give rise to vicarious liability. And then we had the case of Morrison's, WM Morrison's. Morrison's, the supermarket, got themselves involved in quite a number of cases over the last couple of years, but this particular one was in respect of a breach of the Data Protection Act, and you might remember it. So a very disgruntled senior employee, when he left, decided that he was going to disclose the payroll data of everybody at Morrison's to everybody. And that was considered, obviously, gross misconduct, and the employee was taken to task for that. And on top of that, however, another class action was brought saying, well, actually, Morrison's let him do that. Obviously, Morrison's didn't say, please go and disclose the payroll data, but Morrison's didn't put in place enough protections to avoid the risk of him doing it. The employees said, well, they knew that he was able to access the employee data. They knew that he was disgruntled, so they should have taken steps to actually stop it happening. But the employer Morrison's on this case were able to say, no, it's not our fault effectively, and we shouldn't be vicariously liable, because that wrongful disclosure of payroll data was not so closely connected with that employee's acts that he was authorised to do, and therefore wasn't done in the course of his employment. So Morrison's at the Supreme Court succeeded, and again, those employees were not able to obtain any damages against Morrison's themselves. So there's possibly been a little bit of a turning of the tide on vicarious liability as a result of those two cases, but it is obviously something that employers are always very much aware of, and training for employees helps to mitigate risks of or helps employers to be able to defend cases where they are said to be vicariously liable. But these two cases, I think, can perhaps be used going forwards as saying, well, look, there are clearly some things that are so outside the course of employment, and certainly from a self-employment perspective, we should not be responsible. Okay, a few discrimination cases. So this is quite a technical case, actually, the case of Heskett. So what happened here was that the Government Department, Secretary of State for Justice, had to effectively tighten its sort of financial belt. And part of its tightening was that they they slowed down the pay progression scales. Now, slowing down the pay progression scales actually had more of an impact on younger employees than it did on older employees. So several smart employees, those smart younger employers, decided that they were going to bring indirect age discrimination cases, and say, well, look, this has had a more negative impact on us. It's going to take us longer to get to those increased pay scales. So we're going to have a direct financial detriment. Now, there is a rule in sort of age discrimination or a rule in discrimination generally, but it's often used in age discrimination, that costs alone cannot justify discrimination. But that's always been seen as quite harsh. So over time, there's been this concept of what we call a costs plus argument, where you have the cost, but then you have to have something else which might then be able to objectively justify the discriminatory effect. And in this case, the costs plus argument put forward was the need to live within its means. So effectively, the need to be able to budget properly. And quite surprisingly, the Court of Appeal said, okay, yeah, we'll accept that as a costs plus argument. You weren't just reducing costs per se. You were doing something so that you could live within your means, because the 2010 public sector pay freeze meant that you had to review your remuneration policies. So although it is arguably still cost related, it was just enough for the Secretary of State for Justice Department to get home on. So worth considering if you're looking at remuneration changes within your organisations and there are age discrimination issues, you might be able to get home on the cost plus argument. Okay, moving to the next discrimination case. This is in respect of what we call PCPs, so where there is a practice, criteria, or policy that's operated by an employer. And where a PCP has an impact on one group of people with a protected characteristic, it will result in potential discrimination claims. Now, in the case of Ishola and Transport for London, the principle in this was, well, does a PCP have to be something that's ongoing? Is it something that has to happen, perhaps on a regular basis? You tend to think policies are things that are ongoing, and practices are things that are ongoing, and they're not just, one-off acts. But the Ishola case was brought on the basis that, well, look, there was a one-off act here, and that one-off act was the failure to resolve a grievance for the particular employee. And the court said, no, a one-off act can't be enough to say that there is a potential PCP in this particular scenario. A PCP really needs something that has what we call an element of repetition. So because you get something wrong once doesn't mean that it's a policy or a practice. If it can be evidence that you're not going to, have a potential of, continually getting it wrong, or, sort of an active policy of continually getting it wrong. So again, a good case for employers on the basis that you'll be able to, push back on employees who say, oh, because you did this one thing wrong and it's impacted on me because of my protected characteristic, you've put in place an unlawful PCP. So that was Ishola. Next case was clarification on shared parental leave policies that employers may have. And a lot of employers were worried that some of the enhanced maternity pay policies they had were being used to effectively say that, well, male employees taking shared parental leave, if they don't get enhanced shared parental leave pay, that's discriminatory because you give enhanced maternity pay to female employees. So, you know, it's a logical argument. And again, this went through the courts until the Court of Appeal decided, no, actually, the correct comparator to decide if it was discriminatory would be a female colleague on shared parental leave and not a woman on maternity leave. They are two different types of family leave and family pay, and therefore there is no discrimination that comes into play where you have an enhanced maternity pay policy, but you don't enhance shared parental leave. So I think, again, you know, a lot of employers were probably quite pleased about the case because it meant that they didn't have to take away or their enhanced maternity pay, or they didn't have to put in place the enhanced shared parental leave pay. So things could stay very much as they were. Okay, the next case is, oh, excuse me, sorry, I've got a dog barking, which I'm sure we've all been used to. I've got a 6-month-old puppy, so I'm just going to give him my hand to bite, and hopefully that'll quieten him down. The case of Gallagher and Abellio was about some of the substantial reason dismissals. And with some of the substantial reasons, you would expect that you have to follow a fair procedure. Section 98 of the Employment Rights Act requires a fair procedure to be followed in respect of any dismissal. In this particular case, there was no procedure followed at all. And the courts were asked to decide, well, is that fair or not, taking into account Section 98? And what the tribunal said was, well, actually, in this particular case, it was fair, because it would have been absolutely futile to have carried out any procedure in this case where there had been a breakdown in the working relations between two particular colleagues. And because it would have been futile and it would potentially have exacerbated matters even further, it was a case of, well, right, let's just go to dismissal on some other substantial reason basis straight away. So remember, some of the substantial reason isn't a fair reason for dismissal where you would be doing a disciplinary process. So you're not, you're not inviting somebody to a disciplinary, but you would normally be inviting somebody to a meeting to discuss the issues that arose that then potentially would give rise to some of the substantial reason dismissal. But the tribunal very unusually here said no, procedures were not necessary in this case. It didn't make the dismissal unfair. But I would say if any of you have read this from the EAT, please do be very careful. And I would say that this is a very rare example of where procedures can be dispensed with. So I think you follow this at your peril, and there won't be many cases where it's going to work for you. Okay, the next case of Evans and London Borough of Brent. I think this is a really worrying case for employers, because what effectively happened was that the employee was very much at fault here. There had been some financial irregularities and the employee was dismissed for gross misconduct. Not only was the employee dismissed for gross misconduct, but the employee actually was required in the High Court when he was sued to pay back a significant amount of money to the employer. I think it was, it was £50,000. But he still brought a tribunal case, quite cheeky, but he still brought an employment tribunal case. His employer said, look, this cannot be fair. Why can he bring a tribunal case when clearly there is no prospect of success of him receiving a financial award? Because, at the very least, we'll be able to say there was contributory fault on the part of the employee, even if there is a finding of unfair dismissal, there, because of procedural irregularities, there will be no financial compensation payable to him because there will be 100% contributory fault award. The court said, look, somebody is entitled to their day in court. So you couldn't strike the case out. He was entitled to a declaration that there was an unfair dismissal on procedural grounds. and it wasn't an abuse of the process for that case to be continued. So I think, again, quite a worrying case for employers, where employees simply want to have their day in court. And we've all had those cases where we think, look, they're going to get nothing out of this. There's going to be no financial award at the end of it. Why are they continuing with it? But employees are allowed to continue with cases and get that declaration of unfair dismissal, and it may be important to them. So yes, so a little bit worrying. And just finishing off on the cases with a TUPE case. So this TUPE case actually concerned a position where there were beneficial changes made following a TUPE transfer, and those beneficial changes were obviously not to the detriment of the employee. Now, the employer here actually wanted the overall general prohibition on contractual changes by reason of TUPE to apply, because they didn't want these beneficial changes that had occurred pre-transfer to actually come into effect. What had happened was that you had 4 transferring directors who had changed their contracts deliberately prior to the transfer to their advantage. And that was clearly a disadvantage to the subsequent employer. And the employees were found to have effectively voided their contracts by making these beneficial changes, because the courts held that there is a general prohibition on contractual changes, even where they are beneficial to the employee. So that was actually a good outcome for the employer there, because this was an employer who didn't want to take on changes that had been deliberately made by the employees pre-transfer. So when you're doing your due diligence and you're looking at whether perhaps senior management or directors have changed things, keep an eye out for this case. I think it's quite useful. Okay, so just finishing, sorry, I did have a couple of cases. I had the case of a couple of weeks ago. You will all have seen that Uber has now decided that drivers are workers. So workers entitled to the national minimum wage, they're entitled to annual leave, they're entitled to protection from detriment, including whistleblowing. Now, this case can't go any higher than the Supreme Court. This is why Uber have had to, obviously, over the last week, make the announcements that they're going to be paying sums with effect. I think it was from last Wednesday, I think it was, or the Wednesday before, to those drivers. Now, the Uber decision concentrated on moving away from the written contract and looking at the reality of the situation, which is what a number of cases have done in this employment status area over the last few years. But what you also had from the Uber case was the issue of, you're looking at, was the legislation intended to protect certain groups of individuals? It was certainly intended to protect those individuals who were subordinate and dependent upon their engaging organisation. And this was very much the case in Uber, that they looked at those drivers and said, look, they are subordinate, they had no chance to negotiate their own contracts, they were dependent upon the Uber bookings, and they were effectively controlled by Uber as well in the way in which they had to operate. One thing I would say is that there's lots of gig economy cases still out there. In Uber, personal service was required, so the drivers couldn't substitute another driver for themselves, because the taxi industry is obviously heavily regulated and they had to have a taxi license. So you might see some other gig economy cases and they don't find that they were workers, and in those situations it may be that it's accepted that they are still self-employed and not workers. And then finally, case last week regarding sleep-in shifts. So anyone involved in the care industry will be interested particularly in this one. But for the purposes of national minimum wage, when you're asleep on your shift, you are not working. And as a result of that, you are not entitled to the national minimum wage. So Royal, Mencap and Tomlinson Blake has clarified again, it can't go higher than the Supreme Court, that sleep-in shifts are not to be considered as working hours and are not to be paid. So that's the roundup of cases. There will be many more cases, but I think, you know, that's a good selection of some of the major cases over the last few months. Simon, have we got any questions?
We're good at this point, actually. They're being very well behaved and maybe time conscious. So no, we're all we're ready to press on to the final section of the restrictive covenants.
Excellent. Right. Well, just to sort of finish off, then I just want to sort of have a few sort of opinion pieces, perhaps, on restrictive covenants. And in 2016, in fact, there was a consultation on whether restrictive covenants should be allowed. Now, that consultation found no, they were fine. It was perfectly acceptable for employers to put restrictive covenants in place. There has been a repeat of that, but on the basis of looking at non-compete restrictive covenants and looking at whether they should be changed. So in effect, what you have is a scenario whereby the restrictive covenants on a non-compete basis could be banned completely. Unlikely, I think, that will happen. Their use could be limited, so it's for a particular role. They could be limited in terms of perhaps time duration. And the whole purpose of the consultation was really to say, well, look, is this providing an unfair restriction on employees? Have we got too much litigation in respect of restrictive covenants, non-compete restrictions? So that was sort of the general purpose. And just moving to the next slide, what I think is likely to be subject to the consultation proposals are some worrying aspects. So there are a number of European countries that provide for the payment of compensation for the duration of the restriction. So you have a scenario whereby in Germany, Italy, I think it is, the Netherlands, if you've got a 6-month non-compete, you'd have to pay the employee for that 6-month non-compete period, which is quite an onerous obligation on the part of the employer. But that is something that has been proposed as part of this consultation. You've also got proposals that should the non-competes be for a limited period. So, you know, 3, 6, 9, 12 months, perhaps depending upon role. And should you have a situation whereby you have got to provide details of the non-compete before employment starts, so somebody doesn't take a role and they're then told, oh, and by the way, here's a schedule of your restrictive covenants. So confirmation of those restrictive covenant terms, I think it's absolutely essential. They should be in place pre-employment, but you know, they aren't always. That doesn't avoid the issue, though, of when somebody might be promoted. And when somebody's promoted and they're asked to sign up to new restrictive covenant terms, how does that work? Possibly before they take the promotion and the amended employment, they are told what those non-compete will be. And then there is a proposal that there should be a total ban on the non-compete use. Now, I was reading a very extensive consultation response by the Employment Lawyers Association that came out very much in favour of the fact that we should do nothing at all with regards to the non-compete, and employers and employees should be free to join up and either take them or not take them. But you know, that is just one particular body that is expressing an opinion about them. And you could also say that the Employment Lawyers Association might be saying that because we get a lot of work out of restrictive covenants in terms of advice and in terms of litigation support that we will give when people breach their covenants. Okay, so moving on to sort of other issues relating to restrictive covenants. Now, for a restrictive covenant to be enforceable, there are really three things that have to be in place. One, they must protect a legitimate business interest. Two, they must be no wider than is reasonably necessary. And three, they must have been agreed. If you don't have those, then your covenant will be enforceable anyway. So the case law that has been considered, a lot of people say the case law already protects employees against unreasonable restrictive covenants. So you don't need the you don't need statutory changes to post-termination non-competes, because the case law already protects employees very well in respect of unreasonable covenants that might be there. Okay, so just moving on to the next slide, just a reminder that the consultation doesn't look at the other types of post-termination restrictions, which might involve non-solicitation and non-dealing with colleagues, customers and suppliers. So basically, where there are trade connections that employers want to protect, they will do so via a variety of non-solicitation, non-dealing, non-interference type restrictions, and the consultation isn't looking at putting any statutory legislation in place in respect of those. Okay, and then just moving to I think a conclusion in terms of other ways of actually protecting business interests. You may have a situation where you've got longer notice periods that you want to use to protect your business. That obviously comes at a cost. You may use garden leave more to protect somebody from going to a competitor. But perhaps slightly less well known is the use of what we call sort of atypical restrictive covenants, where you would have a financial impact on an employee by reason of the fact that if they leave, their bonus or their shares may be impacted. And on that basis, where you have those atypical restrictive covenants, those can still be used, although it could be considered that they are an unfair restriction in themselves. You'll also have as well strong confidentiality and IP clauses that may well be used as other ways to protect you. So that's really all I wanted to say about restricted covenants, but keep an eye out on the responses that come back from the government, and we could see some change in this area. And I think it will be interesting as to what happens and whether employers' attitudes to restricted covenants do change. So I'll just let Simon see if there's any questions on this.
Hello, we do have, there's a couple on this and then one that harks back to the previous piece. So if we stay with the current, one person's asked, when will these non-compete restrictions be confirmed? So the time frame. Oh, Rebecca, you've just popped on mute.
Oh, I'm sorry. Yeah. So the consultation finished end of February. Obviously, all things COVID related, things budget related have probably, sort of delayed. But I would expect we always use words like early summer, which is probably late spring. But I would expect by June, July, we'll start to see, some sort of response to the consultations that, employers and trade bodies have put in. And employee, union bodies have put in regarding this. So yeah, so I keep an eye on it, sort of probably from June onwards.
Great, thanks. There's a comment here from someone. They unfortunately lost their career in the city in the futures market with a non-compete from a particular bank. They weren't allowed to work in the same market for 12 months after leaving, and the entire department was made redundant a day after Black Wednesday. And the comment there that it's the type of job that if you're out of the industry for that period of time, it would be very challenging to get back in. And the non-compete agreement was agreed was lawful at that point.
Okay. Well, 12 months is a long time, but it depends very much on the actual, sort of the role, the industry sector. And just because you're made redundant doesn't mean that a non-compete or any other restrictive covenant clause becomes defunct. It doesn't matter what the reason for the dismissal or the termination is. apart from where you have a situation where there is a constructive dismissal. So if there has been an issue whereby you have got a breach of contract on the part of the employer, then they can't rely on the restrictive covenants then. But 12-month restrictive covenants in industries like insurance are quite common because of the cyclical nature of renewals, etc. But the duration is always something that you look at challenging.
And lastly, sorry, after you.
Yeah, I've just seen, will the sleeping work judgment affect other industries such as fire service? Well, absolutely. I think if you're I don't see why it wouldn't. It's very much about what you are doing whilst you're sort of effectively sleeping in. Although in the MENCAP case, it did say that whilst somebody was not performing duties, whilst somebody was not required, then they could effectively do things at leisure. Now, their at leisure was obviously sleeping. It may be that the fire service, will have, their own contractual rules regarding this, and those contractual rules will be in place already. But yeah, I mean, I think anywhere where there is shift work that has a requirement of sort of sleeping in and on-call work will be affected by the MENCAP case. Absolutely.
That's great. Thanks, Rebecca. And thank you all, really. I suppose we're there, aren't we? Bang on time.
We are bang on 1 o'clock. So
ardent
everyone
pros
that either wants to have their lunch now or has to go to a 1 o'clock appointment, then hopefully we've kept you exactly to time. So thank you very much for staying with us, everybody.
Excellent. Well, obviously, my thanks to Rebecca, who's done all the heavy lifting here today. So thanks so much for your time and your effort in putting this together. Thank you all for coming. Obviously, it's great. I'd love to say it's great to see you all, but clearly I can't see any of you. But thanks for joining us. The slides will be sent out to you all individually via email. We'll also make the webinar recording available through our own channels, Alexander Lloyd on our YouTube channel, and we'll probably post something to it on LinkedIn. I imagine DMH will do the same. We'll obviously share the recording there. Any further questions, obviously feel free to reach out to myself and or Rebecca directly through the usual channels by email, and we'll do our best. And you should have some feedback forms landing with you any minute. We'd really appreciate your feedback on today and your ideas for future topics. Really, I think that's everything. There's, if you could make your way quietly to the exits, we'll see you next time. And well done to both Rebecca's dog and mine, who you wouldn't have known, would you? Many thanks, everyone. See you soon.
All right. Thank you. Bye, everyone. Bye.